right, shall we get started, Chris?
Sure.
All right, well, if you're here for the webinar, you're in the right place. And Chris Johnson's going to give us an introduction for what we're doing here today. Thank you very much.
And I really want to thank everybody for joining us today. NCAI Connect is a monthly meeting that is free to everyone. And the goal is to provide relevant topics for the North Carolina Appraisal Institute members and the general appraisal community as well. The next meeting is going to be June 18th at 10 a.m. Don Rogers, which is the Executive Director of the North Carolina Appraisal Board, and Tom Lewis, the Deputy Director and Lead Investigator for the North Carolina Appraisal Board, will be our guest. They will cover the complaint process, hybrids and bifurcated appraisals, evals, rulemaking, upcoming regulatory issues, and what they see as common complaints and errors made by appraisers. Don and Tom both thought it would be a great idea if the members would send questions that they would like to be addressed during the meeting. And I'll give you an email address shortly. So anything that you would like them to discuss or answer for you, there'll be a chat session as well. But if you send anything ahead of time, they'll be more than happy to kind of make sure they cover that thoroughly. And please give us suggestions for upcoming speakers. Claire Alfrance suggested Peter Christensen to be a speaker, and here he is. So your suggestions are much appreciated and welcome. You can send those suggestions and questions to the executive.director at the North Carolina Appraisal Institute.org. So we welcome all suggestions, please. Peter Christensen has been very gracious to give us his time. He's an attorney and a member of the bar in California and Washington. His law practice focuses on legal and regulatory issues concerning real estate evaluation. Clients include appraisal firms, management companies, and other providers and users of the valuation services. He is a former general counsel of the Appraisal Institute's endorsed E&O provider, LIA, administrators, and insurance services. And I really do appreciate Peter taking the time to provide great information for the members today. So thank you so much, Peter.
All right, thank you, Chris. I'm super happy to be here, sitting here in Santa Barbara today. Of course, like everybody in California and most other states, I'm sitting at home. I'm in my workshop, so in full transparency, I want to show people what's behind me. You're seeing a virtual background of Santa Barbara, California right now, but that's just virtual because I'm really sitting in my home workshop, and I'm going to show you here. So that's where I'm really sitting. So I've got my tool drawers and my little nuts and bolts bins right in back of me, but it's all business now. So I'll get started. And Chris, you feel free to interrupt me. I'll get into how people can do Q&A along the way today. So let's take a look at what we're going to talk about here today. So it's a 2020 legal and risk issues for appraisers. And where am I going to be going this morning? I'm gonna, of course, because we're dealing with COVID, I am going to talk about the potential liability impacts for appraisers that might stem from the COVID-19 crisis. I'm going to talk about some concerns for future liability in relation to appraisal work generally. I'm not going to be scaring you, I don't think. I'm just going to be giving you a realistic viewpoint and some things that you can do about it. So I'll be talking about examples of suggested language that you might consider in appraisal reports. And also I'm going to talk about the single most important liability prevention measure that you as appraisers can take, whether you're commercial or residential, in every appraisal report of every type. And this is, even leaving COVID aside. It's very important in relation to COVID, but leaving COVID aside, and we'll eventually get through this crisis, what's the single most important thing that you can do, in my opinion, based on over 8,000 appraiser liability claims? And so I'm aiming for about 50 minutes here. Okay, so I'll do a little light housekeeping here about some of the things. I don't want you to worry out in the audience. I can't and won't be turning your microphones on. There's no way that Chris and I can hear you, what you're doing out there. This is a webinar format. It's not like the Zoom meetings. It's those meetings where everyone's on video and everyone has audio. Those have been kind of a little bit more problematic sometimes. But here, the audience is, we can't hear you and we can't see you. The slides that I'm using today will be available later today on a website that I operate, and also I'll of course give them to the chapter, and the chapter can add them if they like to its great COVID page. But my website is valuationlegal.com, and so up here, like, I'm showing you a screen shot of my website, valuationlegal.com, but there's a resources tab, and I'll have presentation materials. So you can see that I've got, like, one of the last webinars I did was on COVID for my own law firm. So they'll be there about an hour after today, after this airs. There'll also be a link to a recording there as well. So if you know someone who wants to listen in later, they can do that. Or if you need to leave today in the middle, you can catch that recording later. We'll also be trying to be getting the recording to the chapter so the chapter can put it on its YouTube channel, something like that. Okay, a little bit more housekeeping here. So we have this Q&A feature in the webinar, Zoom webinar. And so if you have questions today, or if, so if you have questions about what I'm talking about, or even I'm going to be talking about like an appraiser case, if you have questions that shoot off of that, put it in the Q&A. I'll see your Q&A. Chris will see your Q&A if he'd like to see it. Then I'll try to answer your Q&A during the program, because I'll see it, but no one else will see your Q&A. So it is kind of anonymous. You can even check an anonymous box when you do the Q&A to send it anonymously if you don't want your name on it. But anyway, regardless, the audience doesn't see what your Q&A is. Okay, so let's start. Let's start with talking about the COVID kind of concerns here, and those are the kinds of questions that I get routinely right now. And so let's start with an actually frequent issue that I get asked about as an attorney quite a bit. And what I'm asked about is questions about legal issues for appraisal work stemming from the COVID-19 crisis. And some of these questions are kind of direct, and they're hard to answer. Because it's not, some of these questions that I get as an attorney, they're not just like what's the correct legal answer, but it can also be what is right, what's morally correct in some of these situations. So here's an example of a question that I got from an SRA performing residential appraisals in Seattle, Washington. And he emailed me this question, actually it was 2 Fridays ago now. And he said, many of the lenders are still requiring interior inspections here. And at that time, the Seattle area was very hard hit, of course, by COVID. They're probably just starting to open up now, but Seattle was very hard hit. And many lenders, he said, are still requiring interior inspections here. Can the bank be held liable if I acquire the virus while doing an inspection and die? Kind of a morbid question. Or what about one of my family members dies because I subsequently infected them? So another version of that question is kind of the flip side. Can an appraiser, the bank, or an AMC be held liable to a borrower if the borrower later claims that an appraiser sickened them with the virus during an inspection? In fact, I had one appraiser who told me that she was about to do an interior inspection of a home again. And on her way inside the home, she'd greeted the borrower outside, and then she was on her way inside the home. The borrower actually threatened, "If you make me sick, I'll sue you." So that was a different version of like threats I used to hear routinely before this kind of crisis. I would hear threats like, appraisers would tell me threats like, if you don't appraise my house for the loan I need at the right number, I'll sue you. I heard that one, but this was the first time I heard a borrower threaten to sue over making them sick. So what about this kind of risk? And this isn't really what I'm going to be focusing on today. This is just get some of these kinds of weird issues out of the way. But I'm not a personal injury lawyer, but to me and the other lawyers that I talk with about these claims are plausible. I mean, they're theoretically plausible legally, and they're plausible factually if there were really some great compelling facts here in this story. But these kinds of facts are unlikely to exist, because what the claim here, whether you are an appraiser and you believe a property owner made you sick, or a bank should be held responsible for sending you out to inspect the interior of a property, or if you're the appraiser being accused of making a property owner sick, the predominant claim is going to have to be some form of negligence. So that would mean that the homeowner didn't know that they were exposing you to the virus, or in a bad case, intentionally exposed you to the virus. And that part is legally plausible. But in the context of appraisals, the reality is these kinds of claims would be very, very difficult to prove, because it doesn't just require that it happened, that you got sick. Whoever wants to sue, whether it's an appraiser suing a bank, or an AMC, or the appraiser being sued, whoever's wanting to make this kind of claim has to show that person actually caused their sickness. Now that's really hard with a disease like COVID, which you can catch at the market or at a small gathering, or potentially, I suppose, walking down the street and someone's coughing. It's so difficult to prove where you got this virus, where anyone got this virus. So because there's just this vast array of community exposures. So the facts would be so hard to prove that it makes these kinds of claims that a lot of people talk about, that I talk about appraisers with a lot, very difficult to prove. So, and in fact, there's even some guidance in North Carolina that I found on this particular issue, and it comes from the North Carolina Realtors Association, and they've got a nice page of COVID-19 related facts. And one of the facts on the NC Realtors website was, should I use a COVID-19 hold harmless agreement? So this is to a realtor, of course, asking this question. Should I have someone sign a COVID-19 hold harmless agreement for sellers that show their homes, but buyers may later contract the virus, or vice versa? So that was really kind of the question that I was going through, but from the appraiser point of view. So the person's asking, should a broker's asking basically, should I have the seller sign some kind of hold harmless agreement that says should I have buyers rather sign a hold harmless agreement that basically says, I won't sue the seller if I get sick while I'm viewing the inside of that home? And the answer from the North Carolina Realtors was, well, before using COVID-19 hold harmless agreements, realtors should consult their brokers and legal counsel in order to assess the risk and effectiveness of such agreements. Because yes, such agreements can be difficult to enforce. In general, a hold harmless agreement protects a party from liability if another party is injured on their property or is injured during an inherently dangerous activity. In the case of a pandemic where the risks associated are not widely known, but is also widespread, easily transmittable, and may not show symptoms for days after exposure, proving causation would be nearly impossible from a legal standpoint. As a result, North Carolina NCAI Realtors does not plan to create a COVID-19 hold harmless form or include language to an existing form. So that was interesting to me. That's kind of my viewpoint too, that I shared, that these claims would be so difficult to prove the causation element that they're unrealistic for that reason. But of course, out in California, we're perhaps more litigious than you are. In North Carolina, our Association of Realtors feels differently, and our Association of Realtors has put out a form that it calls the Corona Property Entry Advisory and Declaration. It's called the PED form in California. And out here in California, brokers and agents actually are getting homeowners, so property sellers, buyers, and appraisers even, to sign these hold harmless agreements before anyone goes inside a property. And basically, I'll show you a little bit of the language. This is what whoever signs this form, so this would be an appraiser or property seller or a prospective buyer, is signing a form that says things like, you understand that showing and visiting properties may be dangerous or unsafe and could expose you or others to COVID-19. And then it goes on to say, the form goes on to waive any claims that this person signing the form might make in relation to these kinds of issues. So you know, and I have heard from appraisers in other parts of the country that they too are being asked to sign forms like this. So my advice to you, if you are being asked to sign a form like this, is, of course, read it through. One thing I don't like in some of the forms is something called indemnification, where you are actually promising to pay the legal bills for the other side if someone gets sick at this property and it's allegedly because of you. That's probably something you don't want to sign. On the other hand, if the form looks fair and you're willing to sign it, then I would suggest, hey, I'll sign this form for you, but I'd like you to give me the other forms that you've had signed by other parties in the transaction. Then you get those and keep those in your work file. And that would help you defend a claim in this remote case of anyone blaming an appraiser for sickening them at the property. But anyway, that's that direct sickness kind of issue. And I don't really see that as a big legal issue in relation to appraisals. It just hasn't been occurring in that way. So what is the more likely legal risk? Let's talk about what the more likely legal risk is. The more likely legal risk really relates to the economic fallout that could lead to liability issues. And in key ways relating to liability and risk, the COVID-19 crisis is really like a replay of the 2007-2009 financial crisis, but it's like it's happening in fast forward. And so all at once we have monetary losses, giant monetary losses, wide-scale unemployment happening, and disruptions of lending and other economic transactions. And then the next question is, well, will real estate price declines occur? So, you know, maybe we're starting to see that, maybe not. That's of course your job to determine that. But what happens when these kind of economic conditions exist? What happens to claims against appraisers? Well, what happens is they increase. When there are more defaults, when there are more problems on loans, when people can't get loans, or when people got loans and now they can't repay them and they think they paid too much for a property or borrowed too much money from a lender, that's when claims occur against appraisers. Claims, that's when they increase. Claims against appraisers have been very low for the last 5 or so years, as we wound down from the 2007-2009 financial crisis. Claims just steadily trickled off as we got years past that crisis. And so if we are really entering a period of economic turmoil, and if we do see defaults and foreclosures in the future, we would expect to see a real uptick in legal claims against appraisers as well. All kinds of legal claims in general, though. So let me talk about some of the suggestions on what appraisers should be doing going forward in an environment like this. I'll have some suggestions on language for reports. Now, in relation to COVID-19, first of all, I want to say, I don't think an appraiser will ever be sued for a general assignment because they didn't mention COVID-19 specifically. I don't think there's something that it's not like you have to have this great explanation of what COVID is and how it can hurt people and how it spreads. And no one's going to get sick for not having a COVID-19 advisory in there. No one's going to get sued for not having a COVID-19 advisory in their report. That's not something that you really need to worry about. What you need to worry about more is the valuation that you're giving on the property, and how accurate it is, and the degree to which you're confident in that accuracy. So in the short term, now as we're just into this crisis, maybe in the beginning, maybe the impact of COVID-19 isn't fully measurable on the prices that you're seeing and on valuations that you're giving. So this is a statement that something like this would be appropriate in the beginning of a crisis. You're going to have to change it over time. So something like, this appraisal was performed following public awareness that COVID-19 was affecting residents in the United States. At the time of the appraisal, COVID-19 was beginning to have widespread health and economic impacts. The effects of COVID-19 on the real estate market in the area of the subject property were not yet measurable based on reliable data. Now, as things become measurable, you can't keep using a statement like this. You need to be adjusting it over time. The analysis and value opinion in this appraisal are based on the data available to the appraiser at the time of the assignment and only apply as of the effective date indicated. No analyses or opinions contained in this appraisal should be construed as predictions of future market conditions or value. I mean, these are good things to say anyway. They're not even that specific to the COVID situation. But of course, as I said, you have to really adjust this kind of language over time as market impacts begin to be observed and as they become measurable. Because what we learned in the last financial crisis when it comes to appraiser liability is it was the appraisers, say in 2008, who didn't talk about the changing markets, who failed to observe and report on those changing real estate markets as prices were declining in many markets around the country in 2008. It was those appraisers who got caught up in claims saying their appraisals were inflated, their appraisals were inaccurate. So if you're not doing your job, frankly, as an appraiser, as the market impacts become measurable in this crisis, then you could be one of those appraisers down the road who has a claim that the appraisal was inflated, that a lender made a loan or a borrower took a loan, borrowed too much money. That's where we would see the claim. So really the most important thing I can say in relation to COVID-19 in particular is to be observing for those market impacts and then to scrupulously be addressing those both in your analyses and in the words that you use in your appraisal reports. So you're not one of those appraisers like in the last go round in the last financial crisis where they were kind of not reporting what was really happening as we got deeper and deeper into 2008 and 9, and as prices in the country declined during that cycle. Okay, so now what about residential appraisers specifically, and these new flexible ways of reporting appraisals that from Fannie Mae and Freddie Mac and other government-sponsored entities? What about these flexible ways of reporting appraisals where there may not be an interior inspection by the appraiser? Sometimes there's solely a desktop. Sometimes you are replacing the entire limiting conditions statements by it's still built in the 1004 form, of course, but then you've got a whole nother section now that you copy and paste into an addendum that contains a slightly revised version. What about appraisals like this? Well, what we think is it's important to restate the obvious somewhere in plain English. Just restate the plain English. When you're doing one of these kind of new flexible ways of doing appraisals, preparing a desktop or an exterior only, it's really important to restate the obvious. We get claims where it's like, did the plaintiff not even read the appraisal? I mean, but part of that is because we appraisers and lender users of appraisals, it all makes sense to them, but sometimes to a borrower, to a third party, it may not make sense to them. So restate the obvious somewhere in plain English in the report, so you're not just relying on the pre-printed words. And so it would be something like, I do occasionally bobble here in moving these slides around. So, okay. Okay, so you'd be saying something like, the appraiser, or I, did not perform a personal visual inspection of the interior or the exterior of the subject property. Say it in plain English in your own type somewhere in the report. It's very important, because when we get into appraiser claims, what's shown is the pre-printed words in an appraisal report in a form don't matter as much as what you type in your own words. Or another example, the appraiser or I, and it doesn't matter whether you use the appraiser or I in an appraisal report, performed a personal visual inspection of the exterior of the subject property from the street and did not conduct any interior inspection of the subject property whatsoever. So you can, you say it in plain English. That's important here. And someone did submit a question, is a copy of the presentation available? Yes, it'll be available on my website for those who tuned in later, valuationlegal.com, in the resources tab, and also be providing a copy to the chapter that it can post. So the slides will be available later. So it's just so important to use plain English in your appraisal reports to explain things, like when you're relying on photos taken by third parties or information supplied by a third party. The form might say it, but again, using your plain English is the most important thing you can do. So an example would be, in performing this assignment, try to make that come back here. Okay. In performing this assignment, due to conditions stemming from COVID-19 and in accordance with guidance received from the lender client, I did not make a personal inspection of the interior of the subject property. I have used photos and information, and you would describe that in plain English, from the borrower. The borrower provided me 8 photos of the inside of the home to depict the current condition of the inside of the home. Just say it in plain English. And then, for purposes of this appraisal, the appraiser assumes the information supplied from these sources is accurate. Just say it like that in plain English. So a question that we get often right now is, for purposes of liability reduction, is it relevant or is it necessary for an appraiser to use an extraordinary assumption? So now I'm talking about liability reduction here. I'm not talking about what the most correct theory under USPAP would be. And so does an appraiser have to use an extraordinary assumption to protect themselves? Now, one of the issues here is that the instructions for these new flexible ways of doing appraisals that come from Fannie and Freddie state that extraordinary assumptions should not be used for their alternative flexible appraisal approaches. And so some appraisers bristle at that. But here's the reality, that stating an extraordinary assumption, using that label in your report, using that part of USPAP hasn't proven in real world claims experience to make any distinction when we have to defend appraiser claims. So Claudia Gaglione, she's the National Claims Counsel for LIA, the E&O insurer, and I have done a lot of research on this. We've looked at 8,200 claims and never found a single claim that was defended in the program where we thought it would have made any distinction for that appraiser to use magic words extraordinary assumption or to use that specific concept, because you do not literally have to have the words extraordinary assumption in your report. But because the far more valuable legal protection for appraisers is, again, that use of plain English to describe what you're relying on. And whether that amounts to a general or an extraordinary assumption hasn't been shown to really be vital for liability prevention. So I don't want you to, as far as liability, I don't want you to get hung up on, oh, I must have an extraordinary assumption. No, using plain English to say what you're relying on, using to describe it, and then works as a disclosure and makes it very, very difficult for any parties out there, that whether they be clients or other third parties, to make a claim about what you've just described. And so someone just asked about, okay, what about a virtual tour provided live over an iPhone by a property manager of a property? Now, this could be commercial or residential. So if you were getting that kind of information and you were going to use that kind of information in your analysis and include it in your report, perfect time to use 2 or 3 sentences to describe that virtual tour in plain English, what you saw in the tour, who provided it, and a little bit of detail of how it was done. That would make me comfortable with you doing that, as long as you had no reason to doubt that someone was sending you something fake or something inappropriate that wasn't working. So you obviously, you can't use information that you know to be unreliable, but if you believe it to be reliable and usable, then as long as you use some plain English to describe what you're using, virtual tour, I'm very comfortable with that liability wise. Okay, so I really want you to explain what you did in the report, make sure that you have support for that in the work file. So you relied on some photos from the borrower. Make sure, of course, you've got those photos and any extra photos they may have given you, any emails where they were transmitting them to you in the work file. If you have special instructions from a lender, make sure those special instructions are in the work file. We call that work file your defense toolkit. So these little extra communications and material like that should be in that work file, because claims against appraisers don't tend to come up until years later. And when you're in a claim some years later, that's when you need to reach into that work file and have those extra notes. What were you asked to do? What special discussions did you have? That kind of stuff really helps us defend appraiser claims years later down the road. So now let me talk about what I think is the most important liability prevention language in appraisal reports of of any type. And this is whether we're in a COVID situation or not, because when what we learned in the last financial crisis and about claims in general is more than 50%, whether you're a commercial appraiser or a residential appraiser, more than 50% of the claims that are made, lawsuits filed against you, come from parties who are not your clients. More than 50% of claims come from borrowers, in fact. Whether you're a commercial appraiser or residential, again, it makes no difference. So a majority of the claims come from borrowers. Then the next most common source of claims would be clients. And then after that, we even have property sellers and other third parties who make claims. So with the knowing that we're perhaps headed into a financial-like crisis because of COVID, knowing that a majority of claims come from borrowers, this is really the most important part of your appraisal report, that you can make changes in or improve your wording to protect you from liability. So now, before I get into some specific language that I would suggest, I want to talk about that in North Carolina, you have some very good law. You have great case law. And so North Carolina is fortunate to have established good case law that's very favorable to appraisers as a result of the last financial crisis and all the appraiser litigation that followed. And so a key case here is a case called Arneson versus Rivers Edge Golf Club and Plantation. And I'll talk about the facts here a bit. So the purchasers in this case, there were, maybe it was about a dozen purchasers of undeveloped resort lots who had purchased lots in Brunswick County in 2005 and 6, so before the last financial crisis. They sued BB&T and an appraisal firm and its two appraisers in a case filed in 2010. So now, when just a quick note, you're also fortunate in North Carolina to have a very good statute of limitations law. Your statute of limitations law now says you can't sue an appraiser for negligence over an appraisal report that is more than 5 years old. So that can be relevant in a claim like this, but I'll leave that aside. You're very fortunate in North Carolina to have passed that law as well. But moving on with the case, the purchasers of these lots allege that the appraisers had negligently and intentionally and otherwise inflated the values of these lots in the appraisals that were performed for BB&T and loans made by BB&T. And the purchasers of these lots allege that they would never have completed those purchases unless the appraisals had been inflated in that way. It's a very typical kind of purchaser-borrower claim we're talking about. Well, as the North Carolina Supreme Court, the case was actually dismissed by a trial court, and then it went to appeal, and the North Carolina Supreme Court decided we're going to take this case. It doesn't even have to go to the Court of Appeal. So it went straight to your Supreme Court. And the Supreme Court in your state summarized those claims as each of the plaintiff's claims against the appraisers depends on an alleged duty of care owed by the appraisers, coupled with assertions that the plaintiffs, so those are the property purchasers, justifiably relied on the faulty appraisals by the appraisers, and that the appraisers caused these plaintiffs injury. So there's two critical things that the court's really saying here. For these lot owners to win this case, they had to show that the appraisers owed the lot owners, these borrowers and purchasers, a duty of care. And they also had to show that the lot owners had to show that we justifiably relied on these faulty appraisals that these appraisers supposedly did. So the critical issue here is a issue that comes up in virtually every case filed by a property owner or a similar party. And that is, did the appraisers owe a duty of care to the borrowers here? That's really the key issue in every borrower case that we deal with. And the Supreme Court, again, your state's highest court, analyzed analogized the situation to accountant liability. There wasn't really a case on point in North Carolina, perfectly on point, about appraiser liability to borrowers. So the court looked to, okay, what about when accountants get sued by third parties who aren't their clients? And the Supreme Court, here's what the Supreme Court said about an accountant's liability. The Supreme Court said, an accountant who prepares financial reports for his client clearly owes a duty of care to his client. So you could say the same thing about an appraiser. You clearly owe a legal duty to your client. However, the duty may extend beyond that to persons whom the accountant or the appraiser knows and intends will rely on his or her opinion. So to talk about appraisers, you will definitely owe a legal duty to your client. I would also say you definitely owe legal duty to parties that you identify as intended users of your reports. But the Supreme Court in North Carolina says that you may also owe a duty to other persons whom you know and intend will rely on your opinions, so your appraisals. Now, if you identified someone as an intended user, you definitely are going to owe them a legal duty under this reasoning. So how'd that get applied in this case? Here's what the court reasoned about these borrowers, these property purchasers who purchased those lots in Brunswick County, and they were suing BB&T and the appraisers and some other parties. This was the Supreme Court said the plaintiffs here, those plaintiffs here, failed to establish that the appraisers owed them a duty of care. The complaint reveals that BB&T, not plaintiffs, not the borrowers, hired the appraisers to evaluate properties for the bank's own internal underwriting purposes. At no time did plaintiffs engage, communicate with, oh, I'm sorry about those bobbles here, communicate with or deal with the appraisers directly, nor did plaintiffs receive, review, or request any information from the appraisers. Okay, so in this case, there was very little information between the appraisers and all these borrowers who were suing. And so what the Supreme Court then did was uphold that trial court's dismissal of the case. The Supreme Court said the appraisers did not owe these borrowers a legal duty, and dismissed the case. So that's a great decision for appraisers in North Carolina, because other states wouldn't necessarily see it such an easy dismissal. But there is just a little bit bad in this case, as there is in many cases. The part here, at no time did plaintiffs engage, communicate with, or deal with appraisers directly, nor did they receive, review, or request any information from the appraisers. That leaves an opening for appraisers to be held liable by third parties who aren't their clients and who aren't necessarily their intended users, because we know that appraisal reports will get into borrowers' hands, especially if you're a residential appraiser. When it's an appraisal on a dwelling, it must be given to the borrower. And then in other circumstances, we can sometimes predict that an appraisal will be received by the borrowers. So what I'm saying is this is a great case. It will help us defend against appraiser liability situations in North Carolina, but we can make it better. You can make it better by including some additional language in your appraisal report. I'll take these cues along the way so we don't have them at the end. I got a question. Do you happen to know the statute of limitations up in Virginia? Offhand, I don't know, but if you go to my website, valuationlegal.com, I've got a chart of the statute of limitations in all 50 states on the website. So anyway, now I want to cover how can you make this case, this law, better for yourself. Well, you do that by including some extra language in your report that goes straight to this issue of can a borrower or even a seller sue you? And the way you do that is to say it in some plain English right in the report, not relying on the form language that might be in your report. It's got to look kind of like you typed it, because that makes it more meaningful. So in your report, where you're addressing other issues in the appraisal, could be in an addendum, can be, you're not going to hide it, you're not going to, but it doesn't have to be the most prominent thing in the report. You just need to say it somewhere in plain English. Yes, someone had an anonymous attendee submitted a good question here, but we actually do communicate with borrowers to get info and inspect the property. Didn't those appraisers in the case do that as well? They may not have in that case because they were vacant lots and for development. So the appraisers may not actually have communicated in that case, but this is what I'm dealing with here. So this is the language that I want appraisers to use to take care of that loose end. So something like this, directed in your reports to the issue of borrowers being the most common parties who sue. We're going to take away the borrower's ability to claim they justifiably relied on your appraisal report. So we'd say something like this: the appraiser has not identified any borrower or any purchaser, borrower, or seller as an intended user of this appraisal, and such parties should not rely on the appraisal for their own purposes. Neither payment for the appraisal nor receipt of a copy of the appraisal by such a party or any other third party means that the party is an intended user of the appraisal. Such parties are advised to obtain an appraisal from an appraiser of their own choosing if they require an appraisal for their own use. Of course, I'm talking about an appraisal prepared for a lender in this case. This appraisal report should not serve as the basis for any property purchase decision or any appraisal contingency in a purchase agreement relating to the property. This language here, you can revise it, you can put it your own words, but saying something like this directed right at the borrower's ability to rely on your reports helps us defend appraisers in case after case. So, because I've been recommending language like this for more than a decade, and it got to the point where I actually started seeing cases where appraisers were using language similar to this, similar to what I've been suggesting, and it really helps get that case dismissed, or a lawyer working for a borrower will see language like that in the report and think twice before they even file it. It helps us take care of those loose ends in that Supreme Court case in North Carolina that I just showed you. So this is really the most important liability prevention effort that any appraisers can make, is to have language in their reports that really just straight out says it. This report is not for the borrower or even a seller, because sellers sometimes sue as well. The better job you do on really honing down who your client is, what the intended use is of your report, who the intended users are, and then including some language like this, the safer you will be from claims against appraisers. Because as I said again, a majority of claims come from parties like borrowers and property purchasers. Now, I do want to remind you of some also very important language that should be in all reports. If you do commercial reports, you'd have a different version of this, but the language that residential appraisers would typically have in their reports is something like this. And I see it in most reports, but every now and then I get an appraisal that doesn't have it. This appraisal report is not a home inspection. It does not guarantee or imply that the house is free of defects or property condition problems. The appraiser is not a home inspector. It is suggested that the borrower secure a professional inspection of the property and take the necessary steps to ensure the house is acceptable to them prior to closing escrow. You can say that in other ways, but language like that is key to defending these property condition kind of claims that we often see from borrowers. So Oh, one more suggestion for on the residential side. If you're using some of these, if you're having to follow some of these various new guidelines from Fannie and Freddie, and this is specific to COVID-19. So if you're having to use some of these flexible report options where you're copying and pasting whole new limiting conditions type language into at the back of the report, you would say something like this. Because of the impacts of COVID-19, the appraiser has been requested to report this appraisal on a pre-printed form that was contemplated for a different scope of work by the appraiser that may normally have included a personal inspection by the appraiser of the property. Accordingly, this appraisal report, particularly the pre-printed information concerning the appraiser's scope of work, limiting conditions, and certifications, should be read in the context of the changes requested and the modified language and text adopted in response to the impacts of COVID-19. Of course, that's only for these flexible type reporting options that appraisers may be asked to do right now. Okay, so just to wrap it up here, what we're really looking at is lessons from the last financial crisis. And so what we see is post-COVID-19 appraising may be similar to the appraisals performed in 2007 and 8 when data began indicating that real estate markets were declining in price and condition. And what we found then was the toughest appraisals to defend in claims following that financial crisis were those in which the appraisers failed to identify the changed markets and declining prices. So they typically, in the last crisis, appraisers were using older and older comparable sales. So we don't want you to be one of those appraisers. So we need you to really stay on top of markets and data. And as that changes, as they change, identify that in your reports and identify the price effects as they become measurable, because that is the key to getting those values right. So that kind of wraps up the substance of what I want to talk about today. In the announcement for the webinar today, we also did promise that we would give away a prize. So the prize is actually a copy of a book that I co-wrote with Claudia Gaglione, and it's published by the Appraisal Institute. I don't know if we can really call it a prize because the book is called Risk Management. Now, that might be kind of a booby prize. But in any case, if you were to go to Amazon, you would see it selling on Amazon for as high as $120. I'll tell you though, you could buy it on the Appraisal Institute's website for $60, $50 if you're a member, or since you're one of my students, you could buy it on my website for $30. So don't go to Amazon, but someone is going to win it right now. And I've got all of the attendees. You can't see this, but I've got all of the attendees on my screen, and I'm going to close my eyes and flick my mouse, and it's going to land on one of the attendees in this spreadsheet that I've got of everyone who signed in. And so if you are the winner of this book, I'm going to ship it to you. So that will mean that you need to email me. So if you're the winner of the book, my email address is peter@valuationlegal.com. I'm also easy to Google. You can find me. If you look up Peter Christensen, attorney, liability, appraisers, you'll find me. But again, and if you have any questions about today, feel free to email me. Again, it's peter@valuationlegal.com. So here's the drawing. Excuse me while I close my eyes and flick my mouse. It would be Renee May is the winner of the book. So if Renee would please send me an email with her address, we'll be shipping that out probably today. So well, there's my email address for anyone who has questions today about today's presentation. And also, if you want to get a copy of the slides, again, those will be posted later on Valuation legal.com, and I'll also give those to the chapter, and they can do what the chapter can do what it would like with those chapters. And I think let's see, I'll just see. Got a few more questions here. I'll see if I can wrap them up. Who can sue when the appraisal is for the government? An appraisal for taxpayers. Can anyone who's a resident in the locality sue the appraiser? This is a question from Brian. That's an interesting question. It's going to come down to really the same case law that I explored in that Supreme Court case. So is this other party, your appraisal is for the government. Doesn't mean taxpayers can sue you or other random parties can sue you. It still comes down to who's your client, who's your intended user, who do you know is going to use or rely on that appraisal. So if your appraisal is for the government, you still want to do a great job in identifying that client, that intended user, and using similar language like what I showed you to really narrow it down. All right, the other questions I were just kind of hi Peter and well wishes. So that's it for today. Chris, did you have, I see, okay, you just unmuted yourself. Chris, do you have anything you want to say before I turn the webinar off?
I just would like to remind everybody, some came in late. This is going to be a monthly webinar meeting that we're going to have. So please give us suggestions of anyone you'd like to have. The next meeting, which is June 18th at 10 a.m., Don Rogers, the Executive Director of the North Carolina Appraisal Board, and Tom Lewis, Deputy Director and Lead Investigator for the North Carolina Appraisal Board, will be our guest speakers. Send any questions you have and any requests for speakers. And I really appreciate Peter taking the time. I think this is really great information. I'm sure the members got a tremendous amount from it. So thank you so much for doing it, and look forward to seeing you again in the future.
All right. Thanks a lot, Chris, for having me. I'm going to take you up on your invitation to join that webinar because I think that'll be very instructive for me as well. So thank you very much, Chris.
Great. Thanks.
All right. Goodbye, everybody. Have a great day. Have a great weekend.